To know about GDPR as a non-EU company. Okay, so I'm going to very quickly go through a few principles here. So the data subject is the owner of the data. So there's lots of terminology within the GDPR. Okay, so the data subject is the person, the owner of the data, and they have rights. And then on the other side, you have processors and controllers. The controller is the person who collects the data, and the processor is obviously the person who processes the data. So processing is a very broad remit, so it covers everything from making amendments to the data, storing the data. Again, pretty much anything that you're going to be doing with that data is classed as processing. So one key concept that I like to use is the data subject is, in most cases, there is a number of reasons why someone can collect and process data. But if you're working on a consent basis, the data is owned by the data subject, the person, okay? And the controller, which may be a company, such as a hotel or a travel blog or whatever, the car rental company, that controller is just borrowing the data from that person. And by borrowing it, obviously you have to tell that person very, very clearly what you're going to be doing with that data and who you're going to be giving it to. So if you're going to be using it for email marketing and you're going to be giving it to a processor who does that for you, then you need to be very clear about that. And the system works that if there is a data breach of any way, it goes back up the chain. Ultimately the controller is responsible for that, and the controller should be making sure that any of their processes are abiding by the GDPR. So very quickly, what is a data subject? So there's quite a broad, sorry, not broad, but a long explanation of this. Basically, it's a human. So it's any natural person. And that person has 8 rights under the GDPR. So they have the right to access their data. And Tim's going to go a bit more into subject access requests in a moment, so I won't go any further on that. They have the right to rectify their data, so tell you kind of, look, you've got this wrong, you need to change part of that information that you hold on me. They've also got the right to erase the data, so that's typically called the right to be forgotten. They've got a right to restrict your processing of that data. They've got the right to be informed, so they have to be informed of what you're doing with that data. And they've also got the right to data portability, so they can ask for that data in a readable format, so they can move it around as they to another provider, for example. And they've got the right to object and the right to object to any automated decision making as well, which may happen in the processing of the data. So the principles that the GDPR is based on is lawfulness, fairness, and transparency. And that's normally where I spend a huge amount of time talking to customers about this, and talking to people about this. For me, this is one of the core principles. If you know that you've got a legal basis and it's fair and it's transparent, a high proportion of the work is already done. And then purpose limitation. So being very, very specific about how you're using that data and what you're using it for. So if you intend to set up an email campaign for at the point of collecting data, or someone signing up to an email newsletter or something, that's fine. Send them that email newsletter, but then don't use that email for other forms of profiling or something like that. And if you do intend doing that, you have to be upfront about it, okay? Then data minimization, so making sure that you're only collecting data that's relevant to the purpose, okay? So if you need an email address and a name to run an email campaign, then just collect those bits of information. Don't collect things, additional information. So many websites have progressive profiling on them, which is fine if you're going to use that data for something specific, but you have to be very careful that you're not asking for irrelevant data. So making sure that the data is accurate and up to date, and making sure that you've got processes for that actually to make sure that you've got a log of the amendments which are being made. So then storage limitation is about holding the data for only as long as is necessary. And that's going to vary hugely depending on the relationship you've got, the type of data that you've got, but basically having a process to know how long you should store that data for and at what point it becomes irrelevant, and then the process for wiping that from your systems. And then integrity and confidentiality is just making sure that you take all of the measures to secure the data to an appropriate level. So those some of the data breaches that Tim mentioned earlier, obviously some companies are going to be more open to hacking than others, but obviously as a technology company or a travel company, you'll need to make sure that your data is well protected. So an example I like to give to this, particularly for people like travel bloggers, is making sure that if you've got a bunch of users on your website and you're using something like WordPress, then make sure that you're doing the security updates. I mean, if you're not doing the security updates on your WordPress website, then you're not protecting that data. So accountability, be responsible and demonstrate compliance. Demonstrate compliance is a really, really key phrase, and we'll come onto that in more detail when we get to the point of what to do about GDPR, which will be in a few slides' time. So over to you, Tim.
Yes, absolutely. So fantastic. And this is, I really echo Paul's words here earlier in the disclaimer that this isn't full and formal legal advice. And I'm going to talk about some of the obligations under GDPR. And these are really some of the key headline obligations. There are more, and there is more detail. But certainly these are some of the key issues that you should be aware of, and really some first points to try and make sure that you're working towards, so you can show that you are doing your best to be consistent and compliant with GDPR. And the first one is the rather nebulous description of the need to have privacy by design and default within your company. And I like to think of this as more of a state of mind than law. It's really about having a culture in your business that places the protection of your customers and your data subjects, your users or subscribers, whoever they may be, protecting their data and their rights as really the fundamental point of any of the actions that you're going to take in the course of undertaking your profession. So whenever you're working on a new process, or wherever you're thinking about a new way of dealing with your the personal data that you hold, the first question that you're always asking is, how do we protect these individuals' rights? How are we going to protect this data? And how are we going to make sure these individuals' privacy is protected as a standard, as a default for those individuals? And the next one, we've got the lawful basis for processing. Now, this is one where a lot of people tend to get concerned about the idea of consent, and consent is really important and is generally considered to be the main point, the main basis of lawful processing, but it isn't the only one. Where you are seeking consent, though, and certainly for many travel organisations and for marketing particularly, consent will be very important to obtain, and it's now a higher bar to get over to achieve a full consent. It needs to be freely given, specific, informed and unambiguous. So when you're giving that consent, or rather when you're seeking that consent from your data subjects, you need to be telling them everything, as Paul mentioned before, that you're doing with that data. And this comes back to those original principles of making sure that you're informing the individuals and making sure that they're agreeing that you can use the data in that way. And the pre-tick box of old, the way that that many companies have historically dealt with consent, where there's a pre-tick box and you need to untick it to say that you don't want to get onto the newsletter list and what have you, that's no longer acceptable. You need to make a clear action, so either to tick that box or to untick that box in order to give your consent. So you can't just have it as a default. It needs to be an actual action taken by that individual. But as I said before, there are other ways of having a lawful basis for processing. It isn't just consent. If you've got a contractual obligation to an individual, let's say if you've sold them a physical product and you're sending it to them in the post, you will need to use their address in order to actually complete the contract you have with that individual. So in that case, it isn't actually specifically necessary to obtain their consent, because you need to use that data. You need to process that personal data in order to complete your contract. If you have legal obligations, so if you're a government body or something like that and you need certain information on people, or an issue that's of vital interest to an individual, so say if an individual was injured and needed to be treated for medical issues, then that individual's vital interest would override the need to get a consent. And likewise, public interest, if there's a general benefit to everyone, then that can be a lawful basis. The legitimate interest basis is a really difficult one, and I certainly wouldn't intend to get into it you could easily fill an hour or more just on that subject alone. But it's one to be wary of. It's not necessarily an interest for yourself, because commercial interest, it doesn't fall within that. It's when you take into account the balance of interests, whether that is legitimate to process the data in that manner. The next obligation is you may need to appoint a data protection officer. Now, this isn't the case for all companies. You definitely would need one if you're a public authority. If your core activities involve regular and systematic monitoring of data subjects on a large scale, and large there is really quite a vague term at the moment. There's not a huge amount of advice on that. Or if your core activities involve processing sensitive data, and that's a particular category of data that GDPR covers in greater detail and offers greater protection for. And those sensitive pieces of data are things like medical data, religious or ethnic background, and that type of thing, that are really extra sensitive to those individuals. Now, if you don't need to appoint a data protection officer, you're not in breach of GDPR if you don't. But I would always advise any company to put someone in charge, even if you don't name them the DPO, put someone in charge of data protection within the organisation, so that the obligation isn't passed around between departments and in fact nothing's ever actually done. Yes, just really to say the data protection officer can be outsourced, and this is something that is done, certainly is, I'd say, more common with companies outside of the EU, but it is necessary to be careful in that situation, because the DPO, the officer, needs to have a really good understanding of your business in order to do their job. And if they're an external appointment, you really need to make sure that they're being brought up to speed with everything that you do, so that they can fulfill that role properly. The next one is the data protection representative, and this is a slightly self-serving one. I'll put my hands up because this is what my company does. This is the sole purpose that we were set up for. And where you have a company which is based outside of the European Union, but they sell into Europe or they monitor people there, they don't have an office in Europe, they need to appoint a representative in the EU to represent their interests, and as a point of contact, essentially a European face to their organisation, so that the data subjects and the local authorities can raise queries with that data control or processor via their representative. It's not required for every company in that situation. If you're a public sector, or if you deal with what's called occasional processing, and again, there's really not a huge amount of advice on that at the moment. I generally say if European individuals make up more than a % or 2 of your income as a business, then definitely you'll be risking falling on the wrong side of GDPR if you intended to rely on that occasional exemption. Moving on, this is really, as I said, this is the main aim, is to have that person who can be contacted by those individuals. And I call this the hidden obligation. And it's unfortunate because the European Union has done a very poor job of advertising the GDPR requirements, certainly outside of Europe. But because this obligation only applies to companies outside of Europe, and because so many companies are basing their preparations on materials and advice that's coming out of European Union countries, they're not becoming aware of this obligation because it's not discussed within Europe. It's something that only applies outside of Europe. And I like to think of this as a European irony at its best, that we've not only placed this obligation on companies outside of Europe, we then haven't really told them a great deal about it. So yes, that's a European fault, I feel, and one that's, I think, going to cause problems for some companies, I think, reasonably quickly. The next obligation is to make sure you've got processing agreements in place. And this is really important between the data controller, who is usually the first point of contact with that data. It receives it in and it controls and decides what's done with that data. And then when it passes it on to the data processor, who's the next step down the chain, that data processor must be limited to what it can do with that data. There must be really strict limits and requirements on what they're permitted to do with that data, because as soon as they're given any discretion to choose how that data is dealt with, it's at that point that they potentially move over into controller territory themselves and face the extra obligations on that. So you need to have a processing agreement between controller and processor that needs to set out certain information, including the subject matter, duration, nature of the processing. It needs to say which countries those are going out, that data is going out to, and a substantial number of details need to be kept within those processing agreements. And again, you could spend a whole hour just talking about those. And in fact, yes, I'm going to go on to the second slide. So the other thing you need to bear in mind is, as a processor, and you'll have seen from Paul's diagram earlier, you can have a processor, but then you may have a sub-processor under them. So the controller may appoint a processor to do some work for them. That processor may then subcontract parts of that work themselves to another company. And there needs to be a pretty much identical agreement, a processing agreement in place between the processor and sub-processor, as was in place between the controller and processor, to make sure that that continual chain of custody and obligations in respect to that personal data is observed by all the parties who are dealing with it. The next one, I've touched on it briefly as well, is around international transfer of data. And this is really, really a key issue. Whenever you send data outside of the European Union, or wherever you pull data out of the European Union yourselves by collecting it from European individuals who are in Europe, you must make sure that there are adequate protections in place for that data within the country that it's going to. And the European Union have actually granted some countries what they call equivalent status, or granted an adequacy ruling. And that's Europe saying that we feel that your country has roughly equivalent rules and protections in place for data that we do here in Europe. And at the moment, you've got countries, Argentina, Israel, New Zealand, Canada, although only commercial organisations in Canada, the rules for public sector aren't as tough, and so they aren't actually granted exemption. And this exemption is really important. If you don't have it, then what you need to do is to be able to evidence in some other way that that data is being protected when it gets to your country and when it gets to your company in that country. And the way that people will usually do that is to put in place certain clauses and certain contractual rules. The US, which, and this is interesting, the US doesn't have itself an adequacy ruling because of the really quite disparate data protection laws in the US. That is very much based on state to state and in fact sector to sector. So there's quite a good rule in respect of the medical sector, but in most other sectors there's very little there. And what we've done historically between Europe and the US is we had something called the Safe Harbour, which was a self-regulated organisation which essentially said that US companies who would self-certify do provide adequate protections. And then along came Edward Snowden, and he pointed out that in fact, no, the NSA was looking at pretty much all of that data, and a lot of the companies that were protected by Safe Harbour or were supposedly adequate were in fact not at all. So Safe Harbour fell over after Snowden revealed that, and the new system that was put in place is called the Privacy Shield. It's potentially open to criticism under GDPR, and you can pretty much guarantee that that'll be one of the first points that the data activists and the privacy activists like Max Schrems will be taking up. But again, it's a process whereby US companies will self-certify to the Department of Commerce that they are adequate in respect of the data protection that they have for their clients' data. Next obligation is around your privacy notice, and this is really key. This is around the transparency part of what Paul was talking about earlier. When you take data from an individual, you need to provide them with details of what you're going to do with that data. So you need to tell them who you are as a data controller, whether you use any data processors, how you would contact the controller, either through their data protection officer if they have one, or through a representative if the company's based outside of the European Union. You need to tell them how long their data will be kept, and you also need to specifically inform them that they have rights under this in respect to their data, and that they may object to the way that that company is treating that data, and provide suitable contact details to do so. And again, that's where the representative information would be kept. The subject access requests, this is something that you really need to prepare for in your organisation, because when they come in, and any individual in Europe may bring a request to you to say, I'm not sure that the data you have is appropriate, I'm not sure if that data is correct, I think it may be over the top for you to have collected details of all of my children's names simply to provide me with a newsletter. And it's through the subject access request mechanism that they'll raise those queries, and they'll send those either directly to the data controller or processor, usually through their data protection officer or their representative, and they're allowed to exercise their rights in that way. And when those requests are received by the company, it's very important to deal with them in a very quick way, and also to make sure that you have the processes in place so that you can do so. So have those processes in place, be ready for those requests, and have someone who's responsible for getting those answers back, because the need to respond is actually a 30-day deadline. So you need to be getting that information back to them really very quickly, or have a very good reason for not doing so. And you cannot charge for those requests. It used to be under the old regime that you could charge a quite nominal amount, to be honest, certainly not an amount that would compensate you for the amount of administrative work that's required to actually produce that information. But it was enough to at least discourage people or disincentivize people from putting mass requests in and using it really as a stick to beat companies they didn't like. Now, you can't charge for those dealing with those requests, but you can refuse excessive requests. So that if an individual is using it as a stick to beat a company and they're just putting request after request in, at some point that company can turn around and say, actually, no, these are excessive, and you're clearly now just abusing the process that exists. Notifications, the data breaches, and we looked at the data breaches, companies like Uber and what have you. There's a legal requirement to notify the relevant EU data protection authorities, and bear in mind there were 28 separate EU data protection authorities who may need to be notified within 72 hours of becoming aware of a data breach that affects the rights and freedoms of an individual. So if you have a breach and all of that data is so anonymized that there's no way that anyone could get any personal information out of it, then you may feel that you don't need to give a notification on that. But we'd always recommend that you sought legal advice on that, just to make sure that you're not perhaps seeing the rosier side of things and taking a risk by deciding not to notify. And if there's a particularly high risk to the data subject, so particularly if it's some of that information that's been lost is around particularly sensitive information, let's say medical statuses or things along those lines, you must also inform each of those data subjects. Now, it's not exactly clear where that line goes and what you need to do to be really putting those individuals at risk that you need to notify them. But again, it's something that's worth taking professional legal advice on if you find yourself in a potential situation of that. The data processing records, and these are really important as evidence, and really what GDPR wants you to do is to show you're working. So you need to produce documents that detail all the records and how you process data. They set out all of the information, and those need to be available for the authorities if they were to ask you for those. And essentially, there's a lot of detail that needs to go into those: when you're taking that data, what you're doing with it, how long you retain it, and what your deletion process is. So again, I'd really encourage anyone putting those records together to really put as much detail as you can, deal with every question that you can do, so that it's clear that you've taken your obligations under GDPR very seriously.